Today I'm going to tell you about Lau versus Nichols, a Supreme Court case that was decided in 1974. In San Francisco, there were many Chinese students who were unable to speak English. Most of them were not being taught to speak English in school, and neither were they taught in Chinese. Instead, the majority of these students were thrust into classrooms and then expected to figure out the material on their own. There were a very few schools that were able to serve a very few non-native English speakers and help them, but most of the students were left on their own. The students who were not provided with English language instruction or assistance with their coursework brought a class action suit against the San Francisco Unified School District. They claimed they were not being afforded their 14th Amendment rights to equal protection of the laws. The question in this case is, did the San Francisco Unified School District violate its non-English speaking students' 14th Amendment rights, promising them equal protection of the laws? The legal provision in this case is the Equal Protection Clause of the 14th Amendment. The 14th Amendment says, in part, "Nor shall any state deprive any person of life, liberty, or property without due process of the law, nor deny to any person within its jurisdiction the equal protection of the laws." At first, the district court denied relief, and the Court of Appeals affirmed that there was no violation of the Equal Protection Clause of the 14th Amendment or of the Civil Rights Act. Then, on January 21, 1974, the Supreme Court reversed the district court's decision, not based on equal protection, but rather focusing on the civil rights of the students. Because of Lau versus Nichols, children who were not able to speak English fluently are still able to get a meaningful education. Instead of focusing on English immersion and allowing the students to flounder, the schools will now actively instruct students on how to speak English. There are some cases that are related to this case. The United States versus Texas was decided in both 1971 and 1981. The Spira versus New York was decided by the Supreme Court in 1975. Flores versus Arizona was decided in 2000, and Williams versus California was decided by the Supreme Court in 2004. This does apply to all of our future classrooms, because schools should be ensuring that all non-native English-speaking students are receiving language assistance, and by the time a student graduates from high school, they should be considered fluent in English. Unfortunately, there is still a lot of work to be done in this area, and perhaps the biggest reason is because the Supreme Court did not set down any pedagogy for schools to follow. Many schools also don't have the resources to hire staff members or buy materials in order to support their non-English speaking students. Here are my works cited. Thank you.